So the Supreme Court is about to decide whether a 14-year-old should be placed on a cheerleading squad based on free speech. Check this out. Hey, welcome to the channel. My name is Nate the Lawyer. If it's your first time here, don't forget to like this video, share this video, and subscribe to the channel if you like what you hear. Let's get into it. So this is Brandy Levy. She was a 14-year-old freshman cheerleader at a public school in Pennsylvania. Now, Miss Levy went out for the varsity cheerleading squad and didn't make it. So after finding out the news, over the weekend, she sent out a post on Snapchat that said, quote,
"It was F school, F cheer, F softball, F everything."
The school got wind of the message, posted off campus on a weekend, and came down hard, suspending Brandy from cheerleading for an entire year.
The school claimed that the post was disruptive to the school environment, even though the post was made over the weekend, not on school grounds, and not during any school activities. So the question is whether the school can punish a student's speech anytime, at home or even on vacation, or was the school's jurisdiction limited to school activities and school property? Ms. Levy then sued the school board with the help of the ACLU. Now it's interesting, both the trial court and the federal appeals court both sided with Ms. Levy, ordering that the school put her back on a cheerleading squad. But the school appealed the ruling to the highest court in the land, the Supreme Court. And now the Supreme Court is taking up this case. Now, here's the legal question. Does the school, the government, have the right to regulate what they call disruptive student speech that occurs off campus during off hours? Now, there's precedent for this action. There's a case called Tinker v. Des Moines. In this case, students wore a black armband to school to show their support for ending the Vietnam War. In the 7-2 decision, the Supreme Court majority ruled that neither students nor teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. The court found that the First Amendment applied to public schools, and school officials could not censor student speech unless it disrupted the educational process. And that because wearing black armbands was not disruptive, the court held that the First Amendment protected the right of the students to wear them. See, that's what the schools are arguing here, that off-campus speech that is disruptive can be regulated by the school under this precedent. It's disruptive speech, and the school is regulating students' disruptive speech that occurs off-campus. The ACLU and Ms. Levy is arguing that the school's jurisdiction is limited to on-campus activities and school events, basketball games, football games, whatever. Now, the school says if the court rules against them, they're not going to be able to hold students accountable for things like cyberbullying that generally occurs off campus and not during school hours. Now, the other side says that criminal laws like anti-cyberbullying laws and anti-cyberstalking laws are the appropriate mechanism to regulate such off-campus conduct. So now I want you to decide. If you believe this student's off-campus speech is protected by the First Amendment, there's a poll in the community tab that asks that same question. So don't forget to hit there and vote. And let me know if you side with either Ms. Levy or the school district. Now, don't forget, if you made it to this part of the video, like, share, and subscribe. And my name is Nate the Lawyer, and I'm out. Peace.